So I'm going to turn over now to if there's no questions, I'm going to turn over now to Mr. Dwain Alexander. Mr. Alexander is a retired Navy captain, JAG Corps. He is our senior civilian advisor. He trained me. He's trained every JAG that's come through the Norfolk Legal Assistance Office for, I don't know, sir, 100 years? Yeah, at least 100 years. When I have questions about anything that is above what I did in my 6 months, he's our guy. He's our expert. He's testified before Congress. He's testified before multiple forums, and he's our guy. He is our legal assistance guy in the Navy, and we're very lucky to have him. So, Mr. Alexander, it's your show, sir. You got it.
Good morning. So I walked in a little bit late, which means that I missed some fundamental stuff that I need to get to now. So would you consider yourselves, raise your hand if you're one or the other, plaintiff's counsel? Okay, that's fair, that's okay. Defense counsel would be the rest of you? Okay. And then the next questions would be, have any of you served as a SCRA representative or a GAL? No? There's an opportunity waiting for you right there. So before we start, what I usually have to do when I do these presentations is kind of give a perspective. We have an entire generation of judges and lawyers who have never served. I understand that many of you in the room have. I don't know about our other audience, whether or not they have served. But I like to give a little bit of background, and there are 3 stories that I think will capsulize this for you. Because when I was on active duty, it was during the initial Desert Shield, Desert Storm, and then that calmed down. We went to some other things. But I remember seeing a cartoon about the Navy in the newspaper that had the 2 guys on an air-conditioned ship pushing buttons that launched missiles, saying, "We too serve," who sit at a desk and launch missiles, while others were in foxholes and doing much more dangerous things. And so I like to give the understanding perspective that even though I may have been sitting at a desk writing briefs and someone may have been sitting at a desk pushing buttons that launch missiles, our people are constantly exposed to the reality that you're next. And I just want to bring that home to you. Have any of you watched or heard General John Kelly's 2010 speech? You missed a real opportunity. I'm just going to paraphrase it because he did it really, really well. But when he gave the speech, his son had just passed, and the speech was a memorial to 2 Marines who had died earlier. There was a change of command, and at the change of command, 1 Marine battalion was switching out with another Marine battalion. As they do, you switch watch duties. The old battalion sends 1 rep, the new battalion sends another rep, and at this change of watch duty, these 2 Marines met. One was from a middle-class family, one was from Virginia, and was the sole provider for his wife, his child, his mother, and his sister, each of them making about $23,000 doing this. But for their Marine fellowship, they would never have met. But General John Kelly was really specific in saying that because of their training, because of their duty, they were as together, as related as though they had been born from the same womb. Now, on this evening, these 2 gentlemen died. And they died heroically and catastrophically. And they wanted to give them medals, but for a medal, you have to have witness. For the Navy, Navy Medal of Honor, you have to have witnesses, 2 witnesses. And there were none, because these were the 2 people who died. The witnesses who were there were soldiers, Iraqi soldiers, who were there supporting the mission also. There were about 100 of them in the barracks that were also at this compound. And so he went out and he did an investigation to make sure that these 2 men were properly recognized. And when he did that, he talked to all of the Iraqi soldiers. And they said to a turn that but for these 2 men, they would all be dead. And here's what happened. After they assumed duty, they were told by their sergeant, let no man nor person who is, no man nor vehicle who's unauthorized pass through these gates. And that was their job. And they said, yeah, we got this, because that's what Marines do. Shortly after they assumed the watch, a large truck turned down the alleyway that led to the base and accelerated. The 2 Marines knew what was happening instantly. They stepped out and engaged the vehicle, stopping it. It exploded. I believe that The motor from the engine was cast 200 yards and destroyed a house. The Iraqi soldiers, the police force that was there that testified, said that they had tried to fight too. They took up arms, they engaged the enemy, but to a turn, as he got close and they realized this was a bomb, they turned and ran. And one of them said with tears in his eyes, any sane man would have left, and all of the Iraqi soldiers who left survived. Some of them were wounded, some critically, but they all survived. The 2 Marines passed. Sometime later, they discovered 6 seconds of videotape. The videotape ended when the explosion happened, and that reflected what happened. And here's what General Kelly said. The 2 Marines stepped out, braced themselves, and engaged the enemy. At no time did they step back, did they step aside. In fact, they leaned in. They emptied their weapons until the vehicle exploded and stopped. And because of them, the 2 people behind, the 50 Marines who were there and the 100 Iraqi sailors, 100 Iraqi policemen were saved. And you kind of expect Marines to do that because Marines are the guys, right? They're the first line. They go in and do that. But they're not the only ones who take this stance for us. Do you remember the USS Cole? Okay. Navy ship comes into a port for a standard refueling operation. They weren't on high alert. And seconds after they dock and prepare their mooring to receive their fuel, they're attacked with an explosion that rips a 60 by 40 foot hole in the side of their vessel. The explosion happened just below the galley decks. There were literally people who were fused into the deckhead. Now, there was somebody sitting in the galley having lunch when this happened. They weren't expecting to be injured. There were people around this accident that happened. There were everybody else on board the ship who responded to this incident. And these were people who were just on a routine. We're doing a deployment. We're pulling in to refuel, and then we're going to go back out and engage in our mission. But they met with that end. The last story I want to share with you is one that happened in 2014 on the USS Mahan in Virginia at Naval Station Norfolk. It was evening. There was a truck that was admitted onto base. They had credentials to allow them onto base. The truck pulled into the parking area for the Mahan. The driver got out and was approaching up the gangway to the ship. The security guard, noticed that he was acting erratically and ordered him to stop, at which point he advanced and engaged the security guard. The security guard was overwhelmed and he retrieved her weapon and began to shoot at the other people who were on the deck. The security force responded. There was a Petty Officer Mayo, who was captain of the watch that evening, who responded. He went to the female guard who was down, saw to her, returned fire against the perpetrator, and in so doing, he was shot and killed. In fact, he was shot blocking the bullet that would have addressed the female guard who was saved. And my point in telling you this, my point in sharing this with you is that when you represent a service member, you're representing somebody who has volunteered to do this. Mr. Mayo never planned to die that day. He was in port in Norfolk, really. How dangerous could this be? The people on the Cole never expected to be blown up. The 2 Marines knew that they were in danger, but they did their job, and that's what all of us do. When Ms. Davenport was up, she mentioned that every mission that we have is critical. We don't have superfluous people. And so as you think about the SCRA and what it does, and as you think about representing a service member either as a GAL or a service member representative or as counsel, I want you to have in your hearts what you're doing, what you're standing up for. So I have that point, and I appreciate your time in listening to the stories. And hopefully for those of you who are watching this, if you don't have the military background, that may be new information. If you're here, it may have just engendered the spirit that we're all here for. That one fight, that's us. I do a lot of consumer law. And in that area, I deal with our most junior people. We are a really unique group. Remember the financial crisis of 2008, 9, and 10? When that happened, my clients were the only people who could get car loans. Subprime lenders were throwing money out the tree, but there's a reason. Guaranteed employment, known income, and young people. I've done this for over 20 years, and I've met with lots of car dealers and lots of lenders, And what they tell me, some of them tell me, is that they want people who are E4 and below. And here's why. You guys have all had teenagers. Well, some of you. Anybody have teenagers? Okay, you have a teenage kid. Now, I have a teenage child, and I love my child dearly. And I think I raised her fairly well, but when I ask her to clean her room, what I get is somewhere between, please don't open the closet door, and it's done, but don't go upstairs. That's the case for most teenagers. When that same 18-year-old teenager goes to boot camp, something happens. When they leave boot camp and they come out, suddenly if you say swab this deck that's maybe 50 yards long with people walking on it while you're trying to mop it, there's no debate. In boot camp, there's some behavior modification that happens, and it's critical to our mission. If you tell a Marine to stand their post, they can't say, you know, I gotta have dinner. It can be dangerous. There aren't debates. There may be some disgruntlement, but there's never a debate, and that's required for our mission to happen. When you go to boot camp, they teach you two basic things: trust the uniform and respect authority. When I look at you in a uniform, sir, I see that you are with me, that you will die for me and I will die for you. We will stand for each other. And that respect is there just by knowing that you have the uniform. If I've been through boot camp and I understand the authority that comes with the positions that we have in the military, when you tell me as an authority figure to do something, I'm inherently inclined to do that. Now take that scenario and put it in front of a high-pressure sales tactic, say at a car dealership, and what you get is, deer in the headlights, I signed it, but I wanted to go home, and they told me if I signed the contract, I could go home. There aren't many defenses to that situation, but there are other details and facts that will help. But what I want you to understand is that when we send you a client, as Mr. Caruso said, we will have briefed it up, we will have done the research. It'll be something that has a good fight with a strong chance of victory because we want you to win for us. But that most of our clients are those people who are still indoctrinated the way we trained them in boot camp. And if you go around any of the car dealers in our area, you will find that they have at least one person who's former or retired military, whose job it is to kind of acclimate them to the fact that we are here together and you can trust me. And once your guard is down, the handshake and stare in the eye works to get you to do a lot of things. The last thing I want to mention before we get into the material is you're looking for cases for the SCRA, and in many instances you may not find them, especially on some of the nuanced positions. First of all, in Virginia, a lot of our actions happen in General District Court, which is not a court of record. And if we have a good case and it goes to circuit court, it gets settled because people who do this as an industry do not want to create bad law. So we've had landlord-tenant cases that went up and they settled at the circuit court level when the judge started ruling against them. I recently referred a case to the ABA pro bono program. It was a car case. Young lady bought a car. She bought it as is. After that, they sold her a warranty. The car had substantial problems and about a 50,000 mileage variation from what was on the contract and what was listed when you did the Carfax. In order to send that case up to the ABA, all the letters that we drafted to the dealership were drafted as though they were going to a judge. So it has the issue, the facts, the law, and what we think should happen. So that's included. All the case research that we did for free on our Lexus program is included with that material that you're going to get. Any memos that we have, their emails or discussions or other things that came in are going to go with that. So you get a complete package, and I would love it if you took a case that I referred and I could work with you on the case, because this is what our passion is. So, Ms. Davenport went into the purpose, and it's kind of up there. You can summarize all that in mission readiness. If our guys aren't focused on their mission, bad things happen. And because it's a very dangerous job, those things can be catastrophic. The SCRA has been in existence since, I think, maybe pre-1864. There was a version of it, not the SSCRA would have been at that time. There was a version of it created for the Civil War. There was a refinement of it created for World War I in 1918. There was an amendment of it created in 1942 for World War II. And then there were subsequent amendments about 12 times throughout its lifetime, resulting in what we have. I think the last major one was maybe 2010. But throughout our nation, we have decided that when we ask people to go forth and risk everything in defense of our freedoms, we should not hamper them by making them second-class citizens because they can't be there when something's going on in the civil arena. Now, not in the criminal arena at all, but in the civil arena, if I'm unavailable due to military duty or I am somehow prejudiced by the fact that I am serving, that should not be held against me in the court. So there are lots of things you can do. You can stay cases, administrative proceedings, court proceedings, and it also allows you to amend and alter contracts. It's been challenged constitutionally, and they found that this SCRA was created under Congress's war powers to raise armies and fight wars, and therefore our ability to modify and terminate, say, a landlord-tenant contract or a vehicle lease is constitutional and valid. So I want you to understand that as you take these laws, they're well situated and enforced. I'm supposed to talk to you about consumer law, and that is one of my passions, and we'll go into that now. A word on the SCRA and consumer law, though. It was written at a time when, originally, when we had a draft, it was written at a time when most people would have acquired something and then joined the military. So a lot of the protections are for things that are pre-service, and that works really good for your reservists, your reserve professionals who have a practice, a law practice or a medical practice, and then they go on active duty and their practice suffers various things. That works very well for them. But for a lot of our people today, their ability to acquire a house, a car, credit, and the things that come with that don't occur till after they're on active duty. So a lot of the protections under the SCRA are for pre-service events. There are some that are post-service, and we'll go into those. But because of that, you need to also be familiar with basic consumer law. And we can do a whole day on this at some other point. But I'd like to talk to you about some fundamental ones. In the supplier of goods, the merchants, there's a rule called, it's the revocation of acceptance. It's Virginia Code 8.2-608. For that to take effect, you have to have received the goods. The goods have to have a nonconformity that substantially impairs its value or use to the consumer who purchased it. It should be something that was not discoverable at the time that you purchased it, because you have a duty to inspect goods that you acquire. You have to give the merchant an opportunity to cure this defect, and if they don't in a reasonable time, you can revoke acceptance. You've already made the acceptance, you can revoke the acceptance. So for a lot of things that we're gonna send to you in a consumer highlight, that law will take effect. There's a federal law called the Magnuson-Moss Act, and the Magnuson-Moss Act provides that if within 90 days of selling you a good, whether it's a car or a sewing machine, the seller also provides you a service contract or a warranty, it reinstates all of the implied warranties. So if the dealer sells a car as is, this conveyance of a warranty or a service contract reinstates the implied warranties. If they give you a warranty or a service contract that only covers, let's say, the powertrain, the transmission and the engine, then this law would reinvoke all of the implied warranties. The implied warranties of merchantability that come with the product. So let's say, you guys know that after each major event, the hurricane in New York, Hurricane Sandy, Katrina, Irwin, Matthews, there were major flooding. And except for Matthews, I don't know what the outcome was for Matthew, somehow thousands, if not hundreds of thousands of vehicles that were flooded were released back onto the market without a salvage title being noted. That means that people are buying cars that have salt water in them. You can vacuum out and clean out the mud, but salt and electrical stuff does not work well together. And sometime in the future, the PCU, the CPM, whatever the central computer is on the car, if it was underwater, it's gonna stop. The electronics in the door or other things are gonna stop. And so if our people buy a car, and the car stops working, the dealer doesn't necessarily want to repair it, we're gonna work that case up, we're gonna write it up, we're gonna talk to the dealer about the UCC revocation of acceptance, we're gonna talk to them about the Magnuson-Moss, we're gonna cite them the various statutes, we're gonna give them an opportunity to cure. And when they say pound sand, we're gonna ask you to help us. But you will be standing on solid, firm ground, because they don't believe that these laws impact it. A lot of things in the supplier industry, and I'm not opposed to all suppliers or all car dealers, but a lot of things exist in a situation where our custom and tradition, or their custom and tradition, has overcome the actual law. And so they're doing what everyone else does that they've always done, in spite of the fact that it may not be lawful. There's one more rule that I want you to be aware of. Was there a hand? And you can ask questions anytime you want, But there's a rule called the Preservation of Consumers' Claims and Defenses. It's a rule published by the Federal Trade Commission. It's, I think, 16 CFR 433(1) and 2. And what it says is that if you are a lender who lends money for purchase money transactions, so in my examples, best examples are cars, either to buy a car directly, so I'm giving you money to then go out and buy a car, or I'm taking as a third party and assigning on a contract that was written up by a car dealership. If something is wrong with that car, you can assert all the claims and defenses that the buyer has against the dealer for fraud, for misrepresentation, for defective merchandise against the lender. And I have found in my practice that most lenders don't want to have their name up in the newspaper in a case. They don't want to have this fight. And my understanding from dealing with the industry is that there is a written agreement, rarely published, between the lender and the dealer that says if you sell crap and we find out about it, you undo the deal. So I've been able to get several deals undone where service members have purchased vehicles on the basis that it was going to be a bigger problem to the lender. And so the lender made the dealership unwind the deal. Now, if you are a credit union or a direct lender and you have no affiliation with the seller, this rule doesn't really work. What I found in my practice is that that is almost never the actual case because there's a lot of money being transacted here. And so even people who are claiming to be direct lenders with no affiliation, they have some tentacles reached out to the dealers to make certain things happen so that they can be assured that the transaction is going to be viable for them. So those are just 3 areas of law. There's one more. Virginia. Virginia has something called the Virginia Consumer Protection Act. It's found at 59.1. The actual good part is found at 59.1 Tech 200. And what it says is that you can't, the best part is probably the article that says you can't use any misrepresentation in a consumer transaction. Now, proving misrepresentation is not always easy, but the standard is not fraud. You don't have to prove intent. What you have to prove is that there was a material fact that was misrepresented. And so with that basis, you can challenge a lot of consumer issues in our market. And again, we will send you the clients. We will document the statutes, the codes, correspond with the opposing party, outline the argument, and we just want you to hit the ball when it's pitched. So we will take care of all of those things for you. In the area of consumer law, there are probably 2 resources that are more valuable than anything else, besides me. One of them is the National Consumer Law Center. They publish a set of books that are recognized as the source for almost anything consumer law. And the other one is the National Association of Consumer Advocates, which is an organization of consumer attorneys who vie to fight for the rights of others in the consumer field. If you take one of the cases again, or if you have questions, from this you'll have all my contact information. Feel free to contact me about anything military consumer. I'm happy to help out because if you're working for one of our people, we're working together. So. Definitions. Like many statutes, we define who we are, who we're representing, what we're doing, and this is true with the SCRA. Service member is defined as is found in Title 10. Military service is active duty, so reservists and National Guard aren't really in the military service for the purpose of this statute, unless for the reserves, they're mobilized for more than 30 days, and for the National Guard, they have to be mobilized under Title 10. So the governor can call them into duty, but if the president mobilizes National Guard, then they become eligible for the Servicemember Civil Relief Act. And Virginia has within its code sections certain provisions to provide protection similar to the SCRA for their National Guard within the state. Dependent is defined in Title 38. Generally, it's anyone who is a minor or a disabled adult that you provide more than 50% of their income or support for. Court, in our instances, means any court, tribunal, administrative body, state, or federal that can make a ruling or a judgment against you. State, we know what those are, but includes the territories and District of Columbia. And then judgments are just the orders and the rulings. When you think about this, I want you to expand your horizons and think DMV. Think other areas of law where you wouldn't normally have an action, but I know that I was in Japan for a while. While I was there, the state sent me a notice that I needed to verify that my truck was insured. And I didn't do it because I wasn't here. And so they suspended my license, and I was subsequently pulled over when I got back. That was a nightmare. And then there was like a $500 fine for having your license suspended and not having insurance. Even though I did, all my stuff is insured. I do this by automatic payments from my account because I travel. The problem with me is that I was a reservist. And I was on more like a 3-week thing in Japan as opposed to a more than 30-day. And so the SCRA didn't apply to me, and I just had to argue and negotiate this down. But had I fit into a category, had I been deployed for 9 months and received that same letter, I could have said, first, my time limit to respond is suspended because there's a provision of the SCRA that tolls the statute of limitations. And second, that there are also provisions that suspend fines and penalties under contract. So there's a lot of stuff you can do if you understand where your rights fall within the spectrum. Protections of persons personally liable or secondarily liable. We as service members who feel that we're brothers with other service members will frequently co-sign on loans that never get paid. That's bad. But also our spouses and our parents help us out in this respect. So if you have a client or maybe a client's parent who comes to you and says, my son bought this car, I co-signed, he's deployed, the car is somewhere in another state, I don't know what's going on, but we're being sued here now as co-signers, the SRA would act to protect those parents and stay the case just as though they were a service member until you can get to the service member to find out what's going on. This is just fundamental fairness. If the person who has the facts to help explain to the court and clarify what the legal situation is unavailable due to military duty, the people who are impacted by that unavailability should also have the right to say, whoa, slow down, don't get a judgment against me until we find out what happened. I'll let you know that frequently when you're overseas and you switch from a shore to a sea command or a ship to a shore command, for some reason, your pay records get dropped. And so there will be some period, weeks or months, because you get paid twice a month, but they actually calculate it monthly and then distribute it twice. There will be some periods where you will not get paid due to no fault of your own. But if you're deployed overseas and you've set up all your automatic payments based upon money going into your account and then paying your bills, there will be a window when none of those bills will be paid. And you won't, unless you're diligently checking your finances regularly, you won't know that until someone is trying to sue you or garnish your wages. And so it's really important that we always remember and consider who our clients are, who these people are, and what we're doing for them. Let's see. Essential rights to reserves. It makes perfectly good sense that if I send the guy who's in the reserves orders saying you're being mobilized for 2 years, report 2 months from now to whatever base and start your training, that they should be able to, upon receipt of those orders, start working on terminating their lease. Because once they're in boot camp, once they're mobilized, we own them. And we're not going to get, we need them to do what they're being trained to do. We're not going to give them time to go home and cancel the lease and do other things. It's not that we're not nice. It's just that you want us to do our job, right? You want us to do the mission of protecting your freedoms. And to do that, that means that we need to have things like this in place. So upon the receipt of a person who's either joining the military or being mobilized as a reservist, upon the receipt of their orders, they can have all the protections of the SCRA to terminate their lease, terminate their car loans or car leases, and to start having those protections that will allow them to focus on their primary mission, which is our defense. Waiver of rights pursuant to written agreement. I think Ms. Davenport touched on this a little bit. This has been the bane of my existence because many of the landlords in our area require that you sign a waiver prior to entering into a lease. Now, it's perfectly legal to waive the SCRA, but that was done for a reason. The reason why the SCRA contains that provision is because they didn't want to impinge the ability of the service member to negotiate his transaction with the opposing party. So let's say, for example, if you've ever been in the Navy, at the waterfront, people have junker cars because there's salt water constantly spraying up, and when we paint things, there's an occasional overspray situation where your new Cadillac will get like gray, gray paint on it, okay? So a lot of people who do this will have cars that are basically disposable. Now you take that car you're deploying and you park it at your friend's house, it gets towed, it's at a towing lot, and it's perfectly legal. It was towed because it was, for some reason, unlawfully parked. But it's only worth $500 to $1,500, and it's been in the storage lot for a while. Would you like to be able to waive your rights so that the towing company doesn't have to go to court and sue you and cost another 90 days so they can sell the car while it's still within the range of them getting what you owe them for the car, right? You'd want to be able to do that so you can waive your rights. It was not intended to be some type of shield for merchants to block the right of a service member to exercise their mission readiness needs. So the informal Attorney General opinion that was mentioned by Ms. Davenport says also in part, and it's the Weidman versus Badcock case, says that in order for a pre-dispute waiver, and so if upon the initiation of the contract, concurrent with that, you're signing a waiver of your rights. For a pre-dispute waiver to be valid, you have to have facts of you have to have knowledge of the basic facts relevant to the waiver. So why am I waiving? What laws am I waiving? Not just the law, though, but what facts are there? Let's say there's a hurricane somewhere in the Mediterranean that causes a tsunami and Somalia gets washed away, or some other country gets washed away, and we send people to help them. Our sailor didn't know that he had just checked in, just rented the apartment, settled down his family, and now he's gone for an indefinite period of time. If you don't have the facts necessary to make the decision about why you're waiving, the waiver isn't valid. And that's an argument that you can make in addition to the fact that it may not be voluntary. I personally believe that if 80% of the market is requiring a waiver, its viability as a voluntary waiver is no longer in existence. The Attorney General opinion, if you don't have it, it should be in your materials, and if it's not, I'm happy to send it to any of you. It is an informal opinion, but it's informal for this reason. We've had several cases that dealt with concession fees, with waivers, with other issues, and because it is always being litigated, the Attorney General has a policy that it will not issue an opinion on a matter that is currently in litigation. And landlords are always suing tenants, or tenants are always suing landlords, so there's never a period when this matter would not be before litigation. So in response to a request from one of our state senators and one of our local judges, the Attorney General issued this informal opinion. But the law stated in the opinion is based upon sound, valid law from the Supreme Court of Virginia and the United States. So the waiver of rights, it's there, it has a purpose. If it's being abused, our people have a defense, and you have something to fight it with. Exercise of rights not to affect certain future financial transactions. The idea here is that if you apply for a stay and you get a stay, during that stay you shouldn't be penalized for exercising your right not to be punished, right? So think about late fees. Think about escalations in interest or acceleration clauses that occur. You can't always win the war, but sometimes you can win the battles that makes the settlement a lot easier. And that's sometimes all we're going for is to make life better. I admit that my clients sometimes exercise poor judgment. Sometimes they do things that may be on the borderline of not criminal, but lawful. And so the other side of that is that I also know that we wouldn't have them if they didn't have a job or a mission. And whether they're a cook or a maintenance or a machinist mate, they're still necessary. So yes, there should be some recourse for doing something that's unlawful. Should it be your security clearance? Probably not. You as taxpayers spend about $150,000 on every service member getting to the point where they're out of their first major school. And then after that, you pay them and give them benefits to do their job, and they go on to other schools as they grow in their career. Every time they get a judgment against them, there's a risk that they will lose their security clearance and not be able to do their job. Do you guys know what CWIS is? When I first heard the term, I was thinking something totally graphic that's not related to what actually it is. But it's a close-in weapon system. On every major vessel that we have something that looks like R2-D2 that's mounted to the side of a vessel. It has a Gatling gun type turret on it, and it shoots out, my understanding is 1,000 rounds a minute. They're radioactive tipped, and the idea is that if you shot a missile at us, we would create a wall of ammunition that would destroy the missile. That is maintained by an E3, junior enlisted. Now, there are people that supervise that person, but the carrier costs $4 billion. On the port side of the carrier, there's a CWIS system maintained by an E3. If the E3 is worried about their rent, their car being repossessed, the court that's pending, and they forget to tighten the bolts on whatever is in there, I don't do this, forget to tighten the bolts, what happens to our $4 billion asset? What happens to the 5,000 people who are on the carrier when something happens to that $4,000 asset? That's the concern that we have. I've only seen this law used once, and it was used, I think incorrectly, but it was by my client. The guy was a Green Beret who was retiring. And as he was retiring, he got blown up. He was still in the field, about to come home, he got blown up. His command processed his retirement papers, but he was in the VA or in the medical system, and so he was not being paid. He was off active duty, and his records got all messed up. His finances got all messed up. And he asserted this, and several creditors just kind of conceded that he had a bad situation and it would be all right. I explained to him that he wasn't using it the right way. There was no stay that was requested. And, you know, as most statutes, if you don't follow the statute, you don't get the protections. You don't request the stay, the penalty doesn't occur during the stay, what do you have? But he asserted it, and there was some validity to that. At least for him, it worked. Default judgment. This is the thing that probably makes us the easiest target. Under the law in Virginia, at least, you have 5 years to sue on a contract. Or tour of duty is generally 2 to 3 years. If you sue a service member and they are not present, you will eventually get a default judgment. And with the default judgment, almost anything is possible. So let's say that you were a merchant or a landlord and you were suing for damages. I believe in Virginia the measure of damages is the fair market value of the thing just before you destroyed it. But if I'm suing someone who's not there, why shouldn't I sue for replacement value? Right? Why shouldn't I sue for things that are maybe okay to claim, but if you had an affirmative defense, you could push back against? So the default judgment is a major weapon against our service members. So in any civil action or proceeding, in every civil action or proceeding, you have to file an affidavit before you can get your judgment, a default judgment. The affidavit states whether the defendant is on active duty, is not on active duty, or you don't know. I will submit that there is no way, unless it's a car accident and you're suing pro se, there is no way that a creditor would not know that the defendant is or is not on active duty. And I don't know how they'd stay in business if they didn't know. When you rent an apartment, do you do an application? The answer is yes. Okay. When you sell a car, do you do an application? Even before you do the loan application, you do a general application to find out who this person is. And you want to know who's their employer. DOD, United States Navy. You want to know what the next of kin is. You want to know things that would allow you to measure their risk as far as loaning them money or giving them your property. So anybody who is suing who operates a business who did not take the time to find out how this person had money to pay $15,000 or $10,000 for whatever it was, may deserve to lose it. That's just my opinion as Dwain Alexander. But if you're operating your business on such loose terms, I think you're creating your own grave. You're just going to fall into it. So I've had several cases where there is a landlord in the Hampton Roads area who puts unable to determine ID card not on file. Please note, it is unlawful, illegal to copy a military ID. Unless you're the federal government, you can't do it. So it shouldn't be on file in the first place. But secondly, if that's all you're relying on, then you're not taking enough precautions. There's a system called the Defense Manpower Data System, DMDC. You can look it up online, and it will tell you if all you have is the birth date and the full name of the service member, or the Social Security number and the full name of the service member, if they are or are not on active duty, how long they've been on active duty, in some cases where they're stationed on active duty. That is, by law, prima facie evidence of the military status of the service member. The Service Member Civil Relief Act still requires that you do the affidavit and requires that you give facts specific enough to allow the court to determine that you did something to come to this conclusion. In addition to that, each case should always have a DMDC statement. It's free unless you're doing 30 of them. If you're doing bulk processing, there is a fee. But if it's an individual thing, It's free to whoever wants to use it. If you make a false affidavit under federal law, it's, I believe, punishable under Title 18 up to a year in jail and whatever fines are available under Title 18. Under Virginia Code 801 Tac 15.2, it's perjury. Because when an officer of the court, which all of you are, makes a statement to the court that is knowingly or arguably false, you've committed perjury and you're putting your licenses in jeopardy. Not only that, there is a judge from North Carolina who relied on the plaintiff's counsel in determining that the defendant did not deserve all of the rights available under the SCRA. That judge was publicly censored by the State Bar for North Carolina, and that's a case that may be in your materials. But I want you to understand that as counsel, whether you're plaintiff or defendant, but especially if you're the plaintiff, and you're representing to a judge information that is inaccurate, and the judge relies on it, and a complaint is filed either against the attorney or the judge that brings up information that the judge, instead of doing independent research, being familiar with the law, decided to rely on someone else who misled them, the judge could be in as much trouble as the attorney. Public censure for a judge is not fun. Neither is it for counsel. It's really important, regardless which side of the line that you're on this, that you understand this law and that you use it correctly. If it's done correctly, it's probably fair to everybody considering the costs that are involved. Stay at proceedings. If you determine that the defendant is on active duty in the military, then there's a 90-day stay, an automatic mandatory 90-day stay. Counsel is appointed for the defendant. Now, counsel means attorney is appointed for the defendant, and that counsel is to use due diligence to attempt to contact the defendant, to notify the defendant that there is a suit pending, and to ascertain whether the defendant has any defenses in this matter and whether he would need to be physically present to assert those defenses. Now, due diligence is however much diligence is due to get the job done. That's somewhere in the case, believe me. It really is. What I have found is that there are attorneys who, for $50, will send a pre-printed letter to the address on the original contract for the service member. They may do an internet search, or they may send a letter to the Navy or military locator, and then they report to the court that they were unable to find the service member. That is not due diligence. It is not. Even if your internet search revealed a new address, and that address was the current address for the service member, we deploy. So you could have my proper home address, but I'm gone for 8 months, and so sending me something there would still not be effective. And for us, this is the denial of basic due process, right? Notice, an opportunity to be heard. And so if I am a Marine or a sailor or an airman or a corpsman, whatever, and I am risking my life for you, and you are allowing my basic rights to due process under the United States Constitution to be denied, something is terribly wrong. I'm urging anybody who would service this just to read the rules and give it a good shot. There are things you can do. There are checklists you can use. But if your goal is to let the process move as quickly as possible and as efficiently as possible for your client, and you're just doing these two things that I've mentioned, I think you're facing future and potential problem. In July, I think in April, the governor signed a law that we worked on getting passed, the amendments to 8.01-15.2. And what that requires is that in addition to the affidavit, the attorney now has the ability to issue a subpoena ducis tecum to the plaintiff to get the materials that would help them to locate the service member. And it prohibits the practice that used to occur for large law firms and large plaintiffs of hiring one person who then became the mill for this process. So now you have to have someone appointed by the court, actually appointed by the court, not ratified or affirmed by the court as you selected them, and they can't be affiliated with the plaintiff. I know that's painful, but it's a process that I think is also necessary. I've had cases where a service member bought a car, was shot, was in the hospital in Richmond. While he was there, he was sued. His wife sent a letter to the court stating he's in a hospital. They were separated. Sent a letter to the court stating he's in the hospital. He will not make this appearance, but there's a reason why. the guardian ad litem, the SCRA representative, never looked at the court file, never asking their information. The plaintiff had been trying to contact and negotiate the service member, and I already talked to the wife, the girlfriend and the wife. It happens. And had this information, but the plaintiff passed the file along, the attorney looked at the address, sent the 2 letters, and did the minimum that was required. In fact, that is not the minimum that's required. So they got the stay, and they got the default judgment. Now, once you get the default judgment, for us, the most important thing is that a service member has the ability to reopen this case. I don't. As a civilian, you get a judgment against me, I have a certain period of time to note my appeal, or it's final, absent fraud. As a service member, you can reopen the judgment. And so for many of our landlord-tenant cases, what happens is, let's suppose that our our service member did have property, they had bad children, misbehaving children. And they spilled Kool-Aid and did their hands on the wall and did horrible things. And it required some repairs, so there were actually some damages. The measure of damage is still the fair market value of the thing before I did that. So you need to know, when did you acquire the carpet? And why did you replace carpet in the whole apartment instead of just the bedroom or just the parts that were damaged? And so there's almost always a defense in those instances, if only to the fact that the damages were assessed improperly, which allows you, again, to vacate the judgment, renegotiate, and settle something that's maybe a penalty for the service member for what they actually did do, because they should be accountable and responsible for the things that they actually do. But it's also an opportunity to make sure that no one is taking advantage of the people who are protecting us. Any questions on that? Yes.
From out of state, I'm from New York. Could you just very, very briefly explain the guardian ad litem process? I'm not quite sure if our process is similar to New York or not, but.
I'm not a guardian ad litem, but here's what I think I know.
Please repeat the question.
Oh, thank you. The question was, I'm from New York, and I don't fully understand the Virginia guardian ad litem process, and you are using the term guardian ad litem and service member representative interchangeably, and so what is one and what is the other? A guardian ad litem in Virginia is an attorney appointed by the court to represent an incapacitated person. The guardian ad litem has a duty to conduct an investigation, to meet with their client, and to report the findings of that investigation to the court. There are ethical rules as well as legal guidelines, and in Virginia, they are specifically trained under those rules and certified by the court to act in the capacity as a guardian ad litem. Something I think should probably happen in some extent for people who are serving as the SCRA representative. But because the definition of guardian ad litem is someone appointed to represent a person under a disability or who's incapacitated, and a service member who's unavailable due to his military duty falls closely within the parameters of someone who's incapacitated or unavailable to represent themselves or their financial affairs, the definitions kind of overlap. And the standards should be the same, that you should conduct some investigation. I mean, at least see if there's proper jurisdiction. I mean, this is first-year law school stuff that people should be doing. You know, is there a defense commonly known or that you may need to look at? What's in the file? Basic stuff needs to be done. Did that answer your question? We're good? Okay. Fines and penalties under contracts. Let's say that the case was stayed. And again, the problem is that on many occasions, General District Court, you don't know there aren't any cases to really support this, or not many. But let's say the case was stayed, and during the period of that stay, there's no penalty that should occur under the contract. Again, think about you're late on something and there are late charges. Homeowners associations generally have late charges and acceleration things during the period that the case is stayed. Those should not occur. Let's say that if you could argue that when your car is towed, you have some form of contract with the towing company who's now holding it in storage. During the 90 days of the stay, penalties under that storage should not occur. Any questions? Okay. Stay and vacation of execution and judgments, attachments, and garnishments. Again, in this case and in some articles underneath the Act, there's a requirement for military effect. So your military service affected your ability to perform whatever was required. In that instance, the court can, on its own motion, and shall, if requested by the service member, stay the execution of the order that was entered and can vacate the stay or attachment or garnishment of the property. So if the order's already been issued and they're about to seize your property, the court can say, whoa, Stop. This person was unavailable due to military duty. They have a defense. We need to know what's going on before we move forward. And this basic philosophy is represented in both the vacation of default judgments and also in many of the other protections that you have later on. What they're saying is that if the service member is impacted by his military service and unable to participate in our civil legal system, that he should have that opportunity. We should slow the system down for him so that we can ascertain what's going on and make sure that his rights are not negatively impacted. The term of a stay, which is kind of amazing, it can be for the entire period of your service and then 90 days thereafter. I think under one of the provisions, it's what would be now 3952, which I didn't put in materials because it doesn't get used as often, but it's used by either plaintiffs or defendants. It allows you to, if you've made an appearance in the case, you can stay that case for a maximum of 90 days, for an initial period of 90 days, if you notify the court that you're unavailable due to military duty and your commanding officer sends a letter saying, I'm not giving this person leave to participate. Happens a lot in family law cases. We're in the middle of the case. I still didn't get no orders to deploy. The court wants to move on, the opposing party wants to move on, but I can't be there. I just have to certify that I can't be there when I will be there, and my command has to certify that I'm not available due to military duty, and they're not going to grant me leave. That's a guaranteed 90 days. After that term, you can request as long as you want. If the court doesn't grant that term under that statute that I cited, the 3952, the court has to appoint an attorney to represent you. So, the statute of limitations, this is a real double-edged sword. What it means for you as counsel is that it limits your liability for missing a deadline, because for us, there aren't deadlines really. So, it tolls the statute of limitations in any period of law. And I talked about this earlier when I talked about the period that you had to notify DMV that you actually had insurance. That's a period in time required by law by an administrative body. But the same thing is the period you have to file cases. And this one does not require a military effect. So it doesn't say that you have to be in Afghanistan or in a submarine or away. It's an assumption that if you're on active duty, that your military duty is going to impact your ability to participate in the system, and therefore the statute of limitations is tolled. Now here's the other side of the sword. Let's say that I hit your car and you wanted to sue me and I'm deployed and gone for 8 months or for 5 years. When I come back, you can say, hey, I know the statute of limitations have run, but there's this federal law that says it's tolled for you and I still want my money. You can come back and sue me. So it works both ways. Yes?
So let's say it is a personal injury suit, and I know someone is active duty, don't I still have to file the Bennett stay to toll the statute of limitations? I didn't think you could wait before you file.
Well, under this statute, if you're trying to sue me and I'm unavailable due to military duty, or if you're trying to sue me, you can file later. There's no military effect. If you want to get the default judgment, you can file, right? And then there would be the attorney appointed, they try and find me. I'd say it was your fault, you ran the light. You say it was my fault, I ran the light. Or they wouldn't find me, you get a default judgment. And upon my return, I'd try to reopen the case and vacate the judgment and assert that it wasn't me, it was your fault. There's a camera, hopefully someplace. But absent that, if you don't file the suit and you're trying to sue a service member, and the time lapses, you can assert this. Now, judges have taken this both ways, and sometimes they add things on. But the statute of limitations is told during any period of active duty. I know. Yes.
Comment. It would be better to file it, wait almost 12 months, non-suited, if your plaintiff's attorney. Have almost 6 months to refile it, and wait another 12 months before you serve it. And by then, your plaintiff, serviceman, would probably be back, or woman would probably be back. When you go ahead and pursue it.
I'm going to try and capsulize what you just said, but it was really good. So the comment was as a practice tip. If you're in this situation in a personal injury case, it would be better to file the suit. Non-suited, wait, did you say 12 months?
No,
File it.
wait 11 months,
Wait 11 months.
non-suited,
Non-suited,
wait 5 months,
wait 5 months.
refile it,
Refile it.
wait 11 months,
Wait 11 months.
and by then you guys gonna be back and your gal's gonna be back.
Exactly. And so that works.
And you lose your one voluntary non-suit. When you do that, that's the only penalty.
The penalty is that you lose your voluntary one non-suit.
But you can get another non-suit with the court's permission.
And you can get another one with the court's permission. And in reality, they're just complying with this law anyway by allowing everybody the opportunity to get their just day in court. So,
And then you could also ask the court to stay it, but you don't want to miss the first statute.
okay. So again, I don't litigate now. I haven't litigated, in a long time. So I appreciate reality coming into my lecture, to my presentation. Thank you very much. Any other questions? Okay. Maximum rate of interest, 6%. So if you had an obligation and then you came on active duty, it's capped at 6%, and it dates back to the period that you came on active duty, which is really nice. Again, works really well for reservists who may have incurred obligations for their practice, or people who may have credit cards that they're bringing on. Most of our people, when they enlist, don't have a lot of credit, so there aren't many interest rates that are at 6% because there's no thing they have that's earning interest. They have no credit history, which is another problem for them when they try and buy things. There were several companies who, at the instance of our speed up to Desert Storm, Desert Shield in the 1990s and 2000s, early 2000s, who didn't understand the SCRA, and the Department of Justice explained to them that the 6% cap really happens and that they had to pay back that interest to numbers of service members in the hundreds of thousands or millions of dollars. Many of those companies are now much more understanding of the Servicemembers Civil Relief Act and work to educate others and enforce it. Protections under contracts for purchase or lease. This is one of those provisions that I believe needs to be modified because it doesn't meet with reality. So I'm a new enlistee. I've just joined the military. I finally have money. I'm going to buy a car. I deploy. I'm overseas. I go from my ship, the USS George Washington, to a shore command in Japan. My pay gets stopped. My car is not paid for, and it's repossessed. But I acquired it post-service. This statute says that you have to have acquired it pre-service, made at least one payment, and thereafter it can't be repossessed without going to court. You can't foreclose on that. There was a case, Chase v. Wiggum, which is 826 F sup 2nd 914, and that was our case that we worked with an attorney to try and get pushed through, and the judge, rightfully in that case, we were trying to get it under what is now 3958, I believe, or 57, which is that you can't foreclose on a lien without going to court. But this statute specifically speaks to security interest installment contracts. The other one is more general. There's some statutory construction there, and the judge decided that the suit should have been brought under this one, in which case there would be no suit because the property was acquired after the fact. But there have been several other cases since that one where service members were deployed or unavailable. Their property was sold or repossessed because of an error, but now they have no property, they still have an obligation, and they have a judgment against them because it was foreclosed on and they're being sued for the deficiency. So it's a protection that still needs some tweaking. Settlement of stay cases relating to personal property. The idea here is that if you have property that has value in it, such that you won't lose anything per se, the court can appoint 3 judges, those are not 3 judges, 3 disinterested parties who will appraise the party. It can then be sold. The equity in the property is going to be distributed to the service member. The secured interest gets their property back to go on and do something. It's a very fair way to handle things, except that in my experience, most of my service members start off paying 20 or 30% more than the fair market value of the car. So there's always negative equity, never any equity to distribute. And the same thing would happen with almost any other consumer item. It's going to depreciate to the point where I don't know how much equity there is, even in a 50-inch flat screen TV after a year. I don't know if there's anything you can get out of it. So great law, have wait to see good application.
On a leased vehicle,
Yes,
let's say.
right there. We're right here. You're there. No, what's your question?
If you have that 90-day stay and it's still being used by, let's say, a spouse or whatever, so it's continuing to depreciate, and let's say someone is deployed for 2 years, how long can that
what you're saying is that you want to repossess a vehicle that's leased. During the stay period, it's being used by someone, so the mileage is going up, and you'd want to intervene. There is a provision, I think, that would allow the court to interject and seize and not get a judgment against the service member for the monetary loss, but do what was equitable for the secured party in that case. But what would usually happen would be that when I deployed, I would terminate my lease. And that's what this statute says. If I get orders to deploy outside the continental United States for more than 100 days, 180 days, 6 months, that I can terminate my lease by giving written notice and a copy of my orders to the lessor or their agent, and then returning the vehicle not more than 15 days after the notice. What used to happen was that our guys would want to buy a car, and the dealer would take them and say, look, here's this one car, but here's a much nicer car. And the monthly payments for it are just a little bit more than this average car, but you have to lease it. And they lease it knowing that we're in the area for a year or two, or that you're assigned to a ship, or that you may be deployed overseas. And we don't want people who lease vehicles do not want their cars taken to Japan or Italy or Iraq or any of the really cool places that we go. So you'd have to leave it here and continue to pay for it under the contract. So this law specifically addressed that problem, saying that you can now terminate those leases. Yes?
Mr. Alexander, you're supposed to say a secret word that proves that people online watch. So what's your secret word?
Wow. My secret word is, this should be really easy, shouldn't it? Cherries. My secret word is cherries. It's my favorite fruit. Okay. Termination of telephone service contracts. Basically the same thing. You're going to an area where you don't have service. You want to keep your number, you can suspend it. If you don't want to keep your number, you can terminate it. You know, when you do this, they want to sign you up for a 2-year contract. You get benefits, and they don't want to let you out of the contract. This allows you to terminate that if you're going to a period where you won't have service for more than 90 days. And in addition to this, if any of you guys write laws or want to write a law, alarm systems. You know, you want to put an alarm system on your house. They also have 2, 3, 4, 5-year contracts. And you get orders you're moving, they don't want you to terminate. And there's no law that really allows that unless it's in the contract. And what happens is that our people ask, because they know about some of these, well, can we terminate if we get transferred? And they say, sure you can. But that's an oral representation. There's not really any proof unless they're witnesses, and that would be my wife, who may be a biased witness, et cetera, et cetera. Enforcement of storage liens. You have something, and you put it in storage. Because you're leaving, you want to terminate your lease, and you can do that under the law that's already been addressed by Ms. Davenport. So you put everything that you own, your extra uniforms, your childhood pictures, your wine collection, maybe not your wine collection in storage, but everything else in storage. And then you're gone. And that thing I keep talking about that happens when you're overseas, shipped ashore and no pay, and suddenly you didn't make a payment on your storage unit, and they sell it. And everything that you owned disappears. It's gone. When that happens, there's a law that says that prior to selling anything subject to a lien, storage lien, mechanics lien, or other lien, but not a secured interest, you have to go to court first. And this has happened a couple of times. We had a client who went to Panama, and while they're in Panama, apparently the Panamanians are really adept at hand carving personal custom furniture. And they had a dining room and a bedroom suite that was hand carved, that was in storage, that was gone. We've had cases where usually it's with cars, you deploy, you leave your car at the apartment complex, you're still paying your rent, the car gets a flat tire or the tags expire. Keeping in mind that in many states, if you're in the military, your stuff never expires. Your driver's license doesn't expire, your registration doesn't expire, because they know you may be unable to come back and get it. Anyway, they towed his car and subsequently sold it for the storage fees. When they did that, the case was, there were 2 cases, BC Enterprises and Gordon versus, I think, Pete's Towing. That's 637 F3rd 454. And in that instance, the judge, the federal judge, who I think was Judge Smith in Norfolk, asked them to get the service member their car back. And they said, first they said, it's not fair, we didn't know he was in the service. And they said, you could have checked. And then they said, it's not fair, we already sold it, how do we get it back? And they said, you reacquire it. So you find the person you sold it to, and you buy it back, and you give it back to the service member. A lot of leverage in that, a lot of leverage in that. And again, it's something that happens more often than you'd like to think about. We, at one point, we changed, or the laws were changed, I think it's 4334 is the bailment interest in a towed vehicle, and they added a line that says must comply with the Service Member Civil Relief Act. They kind of give notice, because what would happen in the past was that you'd say that it was under a certain dollar amount, say $10,000, DMV would say, okay, you can sell it, and it would be gone. If it was a more expensive car, there were more protections that were in place. But for your cars that most of my guys would own, since the storage place is doing the assessment of its value, it would fall under, they would sell it to themselves, put it on their lot, and recycle it. This stops that process. I'm at 10:30, and I have like 2 more slides. Am I good? You're good. Okay, thank you. Yes. Okay, certificates of service. We talked about this is the DMDC thing. In any proceeding under this chapter, a certificate signed by the secretary concerned is prima facie evidence as to the following facts, and there's a long list, but I only included these 2, that a person is or is not, has been or has not been in military service. If you are suing a service member and you are not attaching this document, you're not doing your job for your client. You just want to make sure that you're catching that. There is another service, I think it's at servicemembers.com. I mean, they actually charge for this thing that is free. So make sure that when you go, you're going to the DMDC, Defense Manpower Data Systems website, where it is free. And again, if your client did not get the full name and date of birth or social security number of the person that they gave $10,000 to, fire them as a client. Private right of action, mentioned a little bit by Ms. Davenport. And this came out of the Gordon versus Pete's towing case, because the question was, can we even deal with this? Is there a private cause of action to pursue? While that case was pending, Congress ruled, passing this in 2010, that there was in fact a private cause of action. Before that, across the country, there was a yay and nay. We didn't know what was going on. But now there is, what that means, and what that means for many of you taking our cases in the consumer arena, is that many of these statutes are fee shifting. So pro bono becomes, please punish the merchant who did something bad by making sure that you get your attorney's fees. And many merchants who understand tradition and custom more than they do the law will make you work for this case. I've seen cases where the attorney's fees were $5,000 or $10,000 and the case was $700, but they just kept fighting, saying, no, you can't do this. No, you can't do this. And they worked it up to that point where, there's a penalty. And so the penalty for plaintiff stupidity is attorney's fees, because the law is there. There we go. Questions, 10:30, 11:30. Any questions? Yes, sir.
Just a quick question. If you take one of the pro bono cases and you file a federal court, does that mean that the EAJ, the Equal Access to Justice Act may apply?
The Equal Access to Justice Act is beyond my scope.
It can, it just depends on the case and what the outcome is. So if you have a favorable outcome, it can apply. So
Is that an attorney's fee issue?
It is.
Okay, so the question was, if you take one of these cases and you file it in federal court, will the Equal Access to Justice Act apply, which is a fee-shifting statute that provides attorney's fees? And the response from Lieutenant Caruso was, maybe.
It depends on the court, depends on if it's considered a favorable outcome. So that's kind of how they judge that, because they do it in the veterans realm.
But it wouldn't be improper to even ask.
Pardon me?
It
No,
wouldn't
it would
be
not.
improper to even ask.
It would not.
The biggest concern for me going forward is that we not make bad law, that we not create cases that cost service member existing rights or diminish existing rights. And to that end, if you take one of these cases and you have any questions, every resource that I have, that we have, will support you, because we want you to be victorious. Thank you very much for your time.
All right, thanks, sir. So I just want to follow up on 2 things. One, he brought up a good point that I forgot. Appreciate the forceful backup, sir. That a lot of these cases, landlord, tenant, and consumer, if you take them pro bono under DSCRA, they are fee-shifting provisions, so they can account for attorney's fees. So that's important. Second, after lunch, after you have all been well fed for free, we're gonna collect those flyers for the what was it? The document we gave you earlier, the registration form. There we go. for the first time. If you have any questions or any concerns about that program, please let me know. This is going to conclude the active duty session. We're going to transition to veterans in the afternoon. Is there any questions on active duty issues that haven't been addressed? Yes.
Let's say you have one of these cases where everything's been sold in storage. How do you guys have the proof for what the value of the property is? Because you can't have someone appraise it because the stuff is gone. How do you prove what it's worth?
Go ahead, sir.
Can you repeat the question?
Yeah, the question was, how do you prove the value of, in the storage case, how do you prove the value of what was put in storage if the items are no longer present?
There are two issues. There frequently in military moves, there's an inventory that's generated, and our people do this with some regularity. The furniture from Panama would have had its purchase orders and other things with it, hopefully. The other thing is that the law is set up so that if you go to court, your rights as both a storage person are protected and your rights as a service member are protected. If you choose not to go to court, my argument would be that but for you, we could have determined, the value, and because you violated the law and lost the property, I don't think you can hold me to a strict standard as to the value. And so if I can find a similar thing out there, we may have to depreciate it to current value. But how do you find the current value of a hand-carved Panamanian dining room table? Again, so then you'd have to get someone you'd have to find someone to assess its value.
And can you get those fees for the service member?
That goes back to one of those first slides when I said most of this stuff happens under a $25,000 level in general district court. And the ones that, if there was something to appeal and the opposing party was going to possibly lose, they just settle it. So all the cases, if we win at general district court and people have that principled matter that I'm going to fight this to circuit court, once a circuit court judge says, yeah, the SCRA applies, and we settle the case, it's done. So I'm sorry, but there aren't rulings, but there are great principled arguments that say it's the right thing to do. And if you give some history and explain some stuff to the judge, we have generations, as I said before, of attorneys and judges who never served and never experienced what's going on. So their ability to draw the nexus to this act, its purpose and necessity for this individual defendant are gone. I have a friend, Patricia Appy, who does family law. And she's had to explain to judges why you can't participate in a telephone conference, because to get from point A to point B, you have to go down this road that's lined with IEDs. And then when you get there, you may not have an open phone line, but that consciousness of our reality isn't always there. Yes, you have internet on ships, but I've gotten several emails stating we're turning off all personal email systems for whatever reason, China, somebody, that we no longer have access to them. So in any given moment, any of our, basic, can I call home, can I send an email, could be gone. No control on our part. And the system needs to understand that, because you, again, want us to do what we do.
We have one more question?
One more question.
Yes.
Does the stay that you have both discussed for court proceedings and other tribunals apply to arbitrations?
Does the stay apply to arbitrations?
Yes.
I'm going to say that it doesn't. I remember seeing some cases recently, because I was thinking, this is us, this is the SCRA. The right to trial, the right to due process has to be there. But I think there are some recent cases that say, and I will look this up and send it to you, because I know it's on my desk someplace, that said that arbitration was one of those things where it was not an administrative tribunal, it was not a judicial tribunal, and so it was outside the scope of the statute. And therefore, but we're trying to get that changed statutorily. DOJ submitted several amendments that would exempt service members from arbitration provisions because it denies us due process. Yes?
I would say this real quickly, that I don't even think arbitration is relevant unless there's a waiver of the service sale member's rights. Because you gotta waive it to be able to say that you're not going into court.
But arbitration is embedded in many contracts, not read, and if read, not negotiable. And so it's just there. And then there's a breach of the contract, and our guy wants to pursue it. Now, usually, many plaintiffs will pursue in court, and unless, I've done this, I've said, but your contract says you have to go to arbitration. Now, I've gotten cases dismissed from my clients where car dealers were suing them saying, you said you wanted arbitration, let's go. And then they drop it, because they don't want to do arbitration either.
Professor McKee, did you have something to add to that?
I think there's a growing body of case law now that's finding arbitration clauses basically unconscionable because of the manner in which they're included in contracts. But even if they weren't, if an arbitration took place and the service person was not able to participate in that, that in and of itself, I think under Virginia code would be grounds for reversing the arbitral decision, because one of the grounds is that a party has not had an opportunity to fully participate in the arbitration, and being deployed clearly makes them out of pocket for the arbitration.
Are you gonna?
You can.
So,
If you'd
what the
like.
professor said was that one of the grounds of arbitration is that you have to be able to participate in the process. And if it would be the equivalent of a default judgment because you were not there, then you haven't had the ability to participate, and therefore you'd have the ability to overturn the arbitration decision. Is that close? Thank you, ma'am.
So we can continue that discussion and certainly let those who are watching and those in the room know when we find the definitive answer, but that sounds like a really good one I'd like to rely on. Before I let these gentlemen go, on behalf of the Puller Clinic, I'd like to award them our Puller Clinic Challenge Coin. Our challenge coin says on one side, serving those who sacrificed, and certainly these two gentlemen do that. It also says heroism, professionalism, and selfless service. We've already given one to Ms. Davenport, who did a great job, but Mr. Alexander, I want to thank you so much. Lieutenant Caruso. And we are going to break for 20 minutes for those people in the room and at home. We'll start again at 12, and you go grab a bite to eat at home, and we will see you back at 12. Thank you also to Deirdre Cherry, who's done a marvelous job of organizing this. That was great.